Hey everybody, it's Mark Ramey with the Mark Ramey Group, and I'm here today with attorney Chris Jones. He's an attorney with the firm Giles Robinson, and I learned something today that was pretty interesting factoid. Chris mentioned that his firm's been around in Orlando since 1905. Is that correct, Chris?
Yep, 1905.
So I want to thank you, Chris, for taking some time because as I have moved forward in my real estate business, I've had the privilege and the opportunity to help a lot of people. And a lot of those people happen to be families who have had people that have passed away, and they had to go through the probate process in order to sell their properties. So
Mhm.
today's focus and questions for Chris is going to be about the probate process. And tell me a little bit about the type of law that you focus on, Chris, with your firm.
Okay, I appreciate it. Thanks for having me, Mark. My practice is primarily focused on, estate planning, wills, trust. Somebody dies, probate process, trust administration. The estate planning side can be anything from simple wills to some complicated tax planning. So that's what makes up about 80% of my day.
Okay. And how long have you been practicing law?
Well, I've been licensed for about 23 years, but I've been at Giles and Robinson for 20 years.
Okay. So I find that hard to believe because you look like you're 12.
I
So,
always say face cream.
all right. So if it's okay, we'll get started with these questions. And let's start off with the first obvious one to me that I think is important is Chris, what's probate?
Okay. If somebody dies owning an asset that needs to be transferred, probate is the process of finding out what assets are out there, figuring out which creditors are out there, going through that process of paying the creditors, and ultimately getting the probate assets to the beneficiaries of the estate.
Okay, sounds like a pretty important job. So, how long does something like probate take typically?
Well, there's a lot of factors. One that we can't change is there's a 90-day creditor claims period in most instances. So most of the time we start the probate in one form or another, depending what type it is, and we have to wait 90 days before we can even consider um, making a distribution. But most of the time, if there's nothing complicated and if everybody gets along, 5 to 6 months is a pretty quick one, all things considered. But it can take much longer if the estate's in a lawsuit or something happens, or we just have creditors to deal with that we can't close the estate without dealing with it, estate can stay open for a lot longer than people would like.
Okay, all right. So it sounds like these are factors that you have to take into consideration case by case.
Yeah, they are. And we're lucky that most are on the simpler side. Somebody dies with an asset or two, we're able to get in there, deal with the creditors and get the assets paid to who it needs to be paid to. So,
Okay, good. Do all estates in Florida have to go through full probate?
no, they don't. There's three main types of probates. One is called a disposition of personal property without administration, and you don't see those very often. Let's say somebody dies with a $2,000 bank account and the funeral was $3,000. You're able to go to the clerk of court and get a court order, which basically just directs the bank to give you that money because the funeral is going to have priority over everything else.
Mhm.
The other type of administration is called a summary administration. And let's say if you die with just the bank account worth 50 grand, you're able to go to the court and get a summary administration order, which says, bank, give that account to whoever's named in the court order. And I will tell you though, in a tight call, I know people like summaries. The idea it's cheaper and simpler. But if anything comes up, what you don't get out of a summary administration is the ability to walk into the bank and say, did mom or dad have an account here? They won't talk to you. So we only like to do summaries when we're 100% sure that we've identified the one asset and we don't have any assets, anything else to deal with. Or, because technically, let's say if you die and you have a car in your name, the bank oftentimes won't talk to the family for you to get rid of it.
Oh,
I mean,
wow.
it would be like me calling the bank and saying, "Hey, I'm Mark's friend. Will you give me some information about his loans?" The answer is no. So we way more often than not do full administrations. Some decent percentage of the summaries where we think we have our hands around everything, we have to convert to a full administration because something comes up. So the answer is no. All estates don't need a full administration, but oftentimes it's just easier and cheaper instead of having to convert it. So
All right. Well, thank you for that clarification. So, what are some examples? I know you a moment ago you talked about assets, and can you give some examples? I've heard the terms probate assets and non-probate assets. Can you clarify that for us?
Sure. There's lots of assets that aren't in the probate estate. That would be insurance that has a beneficiary designation, 401k, IRA, annuities, which have uh, beneficiary designations, or if there's, say, a joint account, joint bank account, or joint piece of real property, or something that has a pay on death designation, all of those are not in the probate estate. But what would be in the probate estate is, let's just say, a checking account only in your name, brokerage account only in your name, real estate only in your name, any property interest only in your name, with one exception, and that's a vehicle. If you die with a vehicle only in your name, you don't need to do a probate. Uh, you can normally go to the DMV with a copy of the will and a death certificate, or just the death certificate, and deal with it.
Okay, that's helpful. So, in the eyes of the law, who is typically legally responsible for handling the probate for the estate?
So technically, I think it's correct to say that nobody is responsible,
Okay.
but there are parties that can do it. Any interested party can start the process of opening a probate estate, but nobody is required to do it. So even if you name somebody in the document, they're not required to do it, but they are the ones that would have priority to get appointed as the personal representative. So any interested party, which could be a beneficiary, a creditor, can open an estate if there's an creditor of yours.
Mhm.
So they're considered interested.
Okay, good. And does now I'm aware, and I've heard multiple terms for this. Does the executor slash personal representative have to, what do they have to do, or when they're tasked with probate management? And what are they responsible for, like as far as like paying bills,
Mhm.
um, managing the money, and so forth?
Mhm. So the personal representative is a fiduciary to both the beneficiaries and the creditors.
Mhm.
So the personal representative, again, has to go out and find the assets and ascertain the creditors to be able to get those creditors paid. Um, all creditors can only get paid from estate assets, but there are sometimes assets which are exempt. So oftentimes, if we've got some creditors and some amount of assets, we're able to save some of those assets for the family as opposed to the creditors, and that's all part of that process. But anything that does get paid, any creditor gets paid from the estate if they get paid.
Okay. So it sounds like, being someone's personal representative, or some to that effect, it sounds really like an honor to do that. And at the same time, it's a significant responsibility.
Oh, it's a job. Occasionally somebody comes in and they struggle on which child to name. And I say, this isn't an award, because it can be difficult. And when there's money involved, the kids that all got along before sometimes don't. When money's involved, you never know what's going to happen. So right off the bat, we tell them they need to open an estate bank account to be able to keep good records, so that if we have to do an accounting at the end, that we'll be able to more easily do that accounting. They have to let us know what the creditors are. So it is a job, and it can take some amount of work, which can be very little, or it can be a significant amount of work if there are complicated issues with regard to the estate.
Thanks for sharing that. I think that's important to note. Should a personal representative hire an attorney?
So if you have a summary administration, you don't have to have an attorney, but you probably should, if only just to give you some direction and advice. But if you have a full administration, you have to hire an attorney in Florida.
Okay. And after a property owner dies, can his or her power of attorney still be used?
No, it can't. So what a power of attorney is a document which delegates authority. So in that instance, if you are my attorney in fact, I delegate to you whatever the document says, which often is anything I can do. I delegate to you. At my death, I no longer have any powers to delegate. So now the power of attorney is no good.
Okay. So, and then I've often heard sometimes where there is no will left. What if the deceased left no will?
Well, that's called dying intestate. So if you die without a will, that's called dying intestate. And in lots of ways, the process can be very similar to if you do die with a will, but it just adds some more complications. So the parties will have to get together if there is going to be a probate administration, get together and agree on who should be the personal representative, or if they don't agree, then they go to court and they can fight about it, but it's obviously easier to agree. If you have real property, you're familiar with this, Mark, if you have real property and an estate and they die intestate, you need to go to court and get a court order allowing the personal representative to sell the
Yes.
real property. And then ultimately, one of the bigger differences is, unlike in a will where you get to direct where your property goes, if you die without a will, the intestacy laws take over and say where it goes. And so there is an ordering of, if they're married and have kids with that surviving spouse, or if they don't have kids with that surviving spouse, if there's a child that's deceased, then the money goes to that child's descendants. So the statute says where the money goes, which, you know, people would obviously more often than not like the ability to choose where their assets go. And the intestacy statute directs where it goes, which can be problematic. I've got an estate right now where there's a child out there that was estranged, and they're going to end up with a significant amount of assets, which probably isn't what the decedent would have wanted. In fact, can't even be found.
Wow.
Yeah.
Wow. Well, so on that note, I'm just curious, when do grandchildren inherit a share and when do they not, when there is no last will?
Mm-hmm. A grandchild would inherit if the decedent died intestate, if the grandchild's parent predeceased the decedent. So a grandchild only gets something if that grandchild's parent predeceased the person that died.
Okay. All right. And then what if we cannot find the original will, but you have like a copy?
Mm-hmm. So you can authenticate a copy. And again, you know, it's a bit of a process, but you have to go and try to find one of those witnesses, and they have to sign an affidavit, and we just have to go through that process of authenticating the copy. But it can be more difficult sometimes because there is an assumption that if you don't have the original, that the decedent destroyed it. So sometimes there are some extra hoops that we have to run through.
Okay. So it sounds like that could take some more time. Why can't I just record the will to change the title to my parents' property in Florida?
Mm-hmm. So wills aren't self-executing. So there are states that have some process like that. All a will does is the will just says, this is what I want to happen if acted upon.
Mm-hmm.
A person in possession of a will has to file the will with the clerk of court within 10 days of the day of the decedent's death. But that's it. You just have to give it to the clerk. But nothing happens automatically under it. So somebody still has to get appointed as the personal representative, and the personal representative has to deal with the assets.
Okay. Which leads me to another question. Can an estate be administered with a missing heir?
It can. The good news about the way some of the probate laws are written is that it assumes that there's going to be people that aren't cooperative. So it makes it so I don't have to get your consent for certain things, that I have a process that I can go through to show the court that your due process rights weren't violated. So let's say if you're missing, I can publish a notice in the paper which basically says, hey, Mark, I'm going to ask to be the personal representative of our mom's estate, and come and complain within a certain amount of days. And if you don't complain, I'm going to move forward. So there are ways that we have that aren't as difficult as we try to find people, but you don't have to. If you can't find them, there are ways that we can move forward. And ultimately, though, this hasn't happened to me in a long time. You might have to pay the beneficiary's inheritance to the Florida Department of Unclaimed Funds or unclaimed property. The clerk can hold it for a while. There are options there. But you can't administer the probate if they can't be found, is the short answer.
Okay. No, that's very insightful. So I guess what happens if a will is contested?
Ooh, get your checkbook out. I'm kidding about that. I mean, a true will contest can be very expensive. So I'll answer that. But before I get to that, I get that question, probably some decent percentage of my estate planning meetings. But I tell people it's extremely difficult to contest a will. There's really three main ways. Lack of capacity to sign the document, and you don't need a really high level of capacity to sign a will. The other is undue influence, where the person who's a beneficiary under the document unduly influenced that person. And undue influence isn't just some amount of influence, it's influence that's so severe that it takes away somebody's right of free will. Um, yeah, and then the other way is if the document wasn't executed correctly. If, let's say, the document needs to be signed by the testator and in the witness's presence. So if you sign your will and then you have one of the folks in the office come in and you say, hey, listen, I signed this, will you sign this now? That's not a valid execution. It needs to be in their presence. So those are the three ways that you can contest a will. And some of those issues are more expensive than others. So if we're going to litigate your capacity to sign a document 3 years ago, you're talking about getting, medical records, and it's very difficult. So I do put people's mind at ease and say, even though it sounds like a nightmare, the overwhelming majority of the time it doesn't happen. But if it is, there's a process and you have to deal with it. So, and there are ways that we can get around on the front end. I've had people come in and execute estate planning documents multiple times. That way they would have to set aside all of those documents, which obviously that makes it even more expensive and difficult. So,
well, I think that, quite frankly, there's so much to this and it's so complex. We could probably ask questions all day long. So I'm just going to end with this final question. In your view, is it ever too late to start a probate?
well, no, sometimes if there's an asset only in the decedent's name, it doesn't matter if they died 25 years ago. In order to get good title to the real estate, or let's say if the Department of Unclaimed Funds says we need some legal authority, you have to open a probate and deal with it. Now, there's creditor claims are only valid for 2 years. So if somebody died 3 years ago, even for property that wouldn't otherwise fit the description of what we could do a summary for, then we can do a summary administration on, say, a $300,000 piece of real estate or bank account, even though it wouldn't have been eligible for a summary then. But if you've got something complicated and you need letters of administration for whatever reason, I have done probates where the person died, decades ago. In fact, I got one right now where screwy title issue, I think we're going back 30 plus years.
Oh, wow. Okay.
Yeah.
Well, sounds like a history lesson. And Chris, I can't thank you enough for taking some time out of your schedule to help the people that are watching today understand this process. If people who are watching this have additional questions, we're going to include your contact information. I imagine it's okay that they reach out to you if they have additional questions.
Yeah, that'd be great. I appreciate it.
All right. Chris, as always, I appreciate your professionalism and your willingness to help. Thanks so much for today. We really appreciate you taking some time.
Okay, thanks, Mark. You take care. Have a good weekend.
You as well.